That's what we're going to try to get into a little bit of the discussion today. The name of the program today is the top 10 documents on the internet that you can access. The reason that I titled this is because these are going to be documents that you can find yourself on the internet. This is how I, brought myself up. Anyway, we got somebody got their hand up. I don't want to put them on hold. Let me plug this person in. 1128, you're on High Frequency Radio. You had a question?
Yes, how are you?
Hey, how you doing today?
I'm good. This is Cia White L speaking.
How you doing, Cia White L?
I'm good. You're a hard brother to reach, but I said let me call in the show and ask my question.
Okay, that's fine.
I'm preparing for a court case, and I have my affidavit of truth prepared, stating that I am accepting all the charges and that I'm the authorized user. What I wanted to know was the process, because I've never been in court, but I have a credit card company that is trying to put a judgment on me, and so I want to settle the case and bring closure to the case prior to going into court. And so if I elect to accept all the charges, do I need to have a bill of exchange at that particular time within the body of my paperwork?
Okay, great question. First of all, before I answer that, let me ask you a couple of questions. First of all, is this the primary credit card, or is this a secondary debt collector? I mean, is this like...
This is a third debt collector, because I was paying an attorney.
Let me tell you something. A third-party debt collector don't have no business doing nothing to anybody in court. All you have to do is hit them with a verification of debt request. That's under the Fair Debt Collection Practices Act, under 15-1692G, or a qualified written request. Make them provide some type of contract or some type of documentation that demonstrates that they have standing to come in court. Because a lot of times what they'll try to do is try to present some type of assignment. You got to look at that assignment real close, because there's going to be some bogus paperwork. Probably going to have some illegible signature on it, won't be notarized, or something to that effect. I mean, the attorneys will play you like you're stupid. A third party, see, they file these court cases like that because 80% of them end up with default judgments.
Right.
That's how they get people. But a third-party debt collector doesn't have standing. So you just need to put in an affidavit and demand that they produce sworn testimony, which you're not going to be able to do, and have them verify the debt. I'll get with you later on that. I got some information I'll share with you on that particular thing. But third-party debt collectors, just hit them with qualified written requests or verification of debt requests. And you can even file the verification debt request in response to whatever they're filed in court. Just make them verify the debt. Just go in there and say, objection, Your Honor, hearsay. Does counsel, we need someone who can testify to the veracity and validity of whatever it is that they are entering into evidence. Do they have someone who's prepared to swear in and be cross-examined? And all these documents they have are forgeries. Do they have original documents? That's the main thing that people have to understand. People have to come to court with original documents. Do they have a contract, an original contract showing that you have any obligation to them, which they don't because they bought the debt from someone, or they claim they did, because a lot of times they don't even buy the debt. They're just going through records and finding some information on you and then start sending you letters doing an administrative process against you.
Mm-hmm.
So that's what happens.
But I thought that you mentioned that we need to be in honor by putting the magistrate on notice.
If you need to be in honor with someone who you have a duty to respond to, meaning that you may have had some type of dealings with them in the past, but you ain't had no dealings with a third-party debt collector. I mean, who are these people? They just came out from nowhere and started saying, hey, we are the Satanic Collection Agency, and, we bought this from American Express, and you owe us some money. And,
right.
who are y'all? You know, and there's people start. So, you know, you guys say, okay, well, wait a minute, hold on. Can you provide me some type of documentation, certified? Matter of fact, I'll do whatever you want to do. Just have whoever can bind your corporation there, maybe the CEO, CFO, or secretary, or someone like that who can bind the corporation, who has the authority to do so, to sign some type of affidavit or some type of affirmation that you indeed are in possession of documentation that would demonstrate that I have some type of contractual relationship with you, i.e. an original contract, or maybe perhaps you have an authentic an assignment from this particular thing, because most of the time these credit card companies write those debts off, and they ain't loaned you anything anyway.
Mhm.
You know what I'm saying? They haven't loaned you anything anyway. So in a situation like that, no, you don't have to give them anything. You make them prove their standing, okay? Standing, y'all, is a threshold issue in any court proceeding. That means before you can begin, they have to demonstrate that they have a bona fide interest in this particular matter. That's what the foreclosures too. The same thing. When you're dealing with a foreclosure, they skip over that step. The judge is supposed to take judicial notice of that sui sponte, and they don't do that. They just ignore it and just go on and start, you know, asking questions. And oh, whoa, hold on, man. Let me check on something. These people over here, what are these people over here? What gives them the authority to come in this courtroom and file a claim? You know, so those are the things that you want to address first. If it was something like a foreclosure or something like that, you don't bring the bill of exchange to court, even though in some states like Chicago, they have statutes that allow you to do that. Believe it or not, I love Chicago. Chicago had some nice, all you people in Chicago listening, y'all got a debtor-friendly state. You know, it doesn't say you can't do that. You can come in court and say, Jan, hey, I got a bill of exchange right here. I want to pay this right now. I've done that on a foreclosure case. I brought it into court. Say, Jan, I got the payment for them right now. And, you know, the judge told me, well, you know, that's a worthless piece of paper. And I just told the judge, I said, well, Yana, that's not for you to determine. That is for that attorney to take that back to his principal, the mortgage company, and they can return it to me with evidence of a defect from a qualified third party, at which time and allow me an opportunity to cure such defect. But absent that, sir, I consider this matter settled and closed. Those are principles of commercial law. Hell, if I give you an instrument or tender a payment, then you need to demonstrate there's a defect in the instrument. That's why they give you instructions on Article 3 of the UCC and the UNICITRAL Convention, the United Nations Conference on International Trade Law. Shows you how to construct a negotiable instrument. There is no money in our society. The only thing that you can do is give somebody a promise to pay. But in giving somebody a promise to pay, you want to make sure that your instrument has all the elements necessary reflected on its face so it can be considered a negotiable instrument. And, you know, that's what that's all about. But there's no money. It's all a big monopoly game. There's no money. Insurance is a scam. Banking is a scam. The court system is a scam. And then behind the entire scam is the need to have people to go to work and work jobs and give their energy to another group of parasites that reside on the other side of Wall Street.
Mm-hmm.
So that's what it's all about.
Thank you.
I'll call you later on. You know, I got your number here, and I will give you some additional detailed information on that. But you don't never have to pay a third-party debt collector.
Okay. Thank you.
All right, you're welcome, sister. No problem. Yeah, these third-party debt collectors, y'all get these letters from these third-party debt collectors automatically. You need to attack the attorney. Ask him who he is. Does he have a bar card? Does he have insurance? You know, does he have a contract demonstrating that he has some type of agreement with this particular company to collect this debt? Do a qualified written request under 15 U.S.C. 1692G under the Fair Debt Collection Practices Act. Do a verification of debt, which I prefer over a qualified written request. but just do an administrative process on these people. Don't just accept these people. These people are thieves and pirates. I have seen attorneys do some incredible things, claiming that they filed a UCC1 against a person. I'm looking at this, it's not even filed. It's fake documents. They'll send you fake documents in the mail, and knowing that because you aren't educated about the law, you look at the documents and think they're authentic. This is why it's important for you to know a little bit of law. These people they'll send you some fake stuff in the mail just to inveigle you into sending them some money. And you never question it. Don't fall for the game. Don't fall for it. But we're going to get into that today. We got a good show lined up for you today. I see everybody chiming in and logging in. Y'all sitting at the desk at work. I thank you for all the emails that you've been sending me. It seems like a lot of people are liking the show. We keep it real on this show. We're not going to give you no bullshit. You know, when you look at these other shows going across the internet, you know, they speak very, you know, everybody's having these discussions and, you know, these online discussions and so forth. And, you know, ain't none of these people, you know, been through anything, you know. So here what we're going to do is we're going to give you the behind-the-scenes information. People have been dragged through the system, locked up and locked down, houses taken and things of that nature, having private conversations with judges and attorneys and different things like that. So we're going to give you the real of what's really happening. I was just listening to, I was on a website, and I was just listening to some guy come on the website talking about Boyko has come down with another decision. And I got to give another message to you foreclosure people out there, because y'all, you know, I understand what you're doing. Some of y'all are new to the game, and, you know, y'all want to believe in our judicial system and so forth and judges and everything. But those of us who have been doing this for the last couple of years, you know, Paul, this is what should be about people. It's almost like when I look at the election. Why do people keep going and electing people every year for president and nothing changes and they get pissed off? Every year somebody's pissed off at the president.
Well,
year after year. I mean, I've been watching elections since Jimmy Carter. And it's the same shit every 4 years. And it's like people really think, you know, they come to me, you know, you need to vote. I mean, like, no, that's not the answer. When something gonna click and people are gonna see, okay, it's not them that we need to be looking forward to do something, it's us that needs to do something. Why are they gonna do that, you know?
I cannot answer you because it's sad.
That ain't not the government. I mean, people say Obama did this. Obama is the chief of the executive branch of government. We have a government that has a legislative, executive, and judicial branch that forms checks and balances on each other, so we do not have a dictator. Obama is not a king. An executive order is not law. A bill is not law. They're calling it law because it has the force of law, because you have contracted with these people and agreed to allow those laws to dictate or rule over you. So it's through your voluntary consent that these laws have power over you, or what they're calling laws, because the only law is instituted by God. Law is unchangeable. We talk about law. A law is something that does not change. Gravity. The law of gravity. Gravity does not change. Those are laws. Learn the difference. But let's get into the show. Let's get into the show today, because I said, you know, I was going to drop the 10 documents that I feel, you know, or you could get on the internet and do some research, because we got some new people out there, and some people out there, I know they're wondering, like, well, you know, what is he talking about? We got some new people, you know, that's probably new to this, this whole thing, and they never like, okay, what are you talking about, man? And there's no money and all these different things right here. So hopefully we got some new listeners out there. And what we're going to try to do today is we're going to try to give you the information that you can go on the internet yourself. I'm going to help you sift through all the bullshit that's out there, because there is a lot of it out there, because you have agents that are out that have been put in place to put out rabbit trails. You will not find your way through this maze. So what I'm going to do is, this is why y'all always hear me talk about the 4 rules of the game, and I'm going to repeat them right now. It's a game. You're on the Monopoly board. If y'all on the stream, you're going to see the Monopoly money compared with the real money on my stream on the internet. And there's 4 rules to this game. And the number 1 rule is there is no money. That is the basis of everything that's happening. When you look at your cash in your pocket, it says Federal Reserve note. That's not money. That is a promise to pay. Look at the serial numbers on it, and then compare it to the number on the back of your Social Security card. Your labor is guaranteeing those Federal Reserve notes. That's why you pay income taxes. That's why 100% of your income taxes goes to pay the national debt. The second rule is public and private. There's a public and there is a private in everything in our society. There's a public side and a private side, and they do not mix. They don't ever mix them. You better not ever mix them. And then there's this thing called honor. Since there is no money, you have to be honorable in all your dealings, and this is where the administrative process comes in. Everything is an administrative process. That's why the guy was talking today. I was listening to him do his rant. He was talking about, I believe we have to do an administrative process prior to going into a fair day. I'm telling everybody that these people are administrators. They're administrators. They're not judges. They are administrators, not judges. And you have to do an administrative process before you go to court to get the judge to act in a ministerial capacity. I guess I got to put that back up on the screen and show you all those citations of authority, but you can Google that yourself. It says that any time a judge is enforcing a statute, he's acting as an administrator. Remember that. Look it up yourself. Get on the internet, do some research. These judges are trying to figure out ways to tell y'all things without telling you publicly, because they can't. They're trying to, issue these opinions. They call opinions. People aren't paying attention. They call them decisions. These are opinions. And some of them are dicta. These other judges in these other jurisdictions do not have to take judicial notice of it. Wow. Anyway, the last rule of the game is do not participate in public plays. Stay out of the courts. When you go in these courts and everything, these are public plays. These people have set up something to fool you with. And I know it doesn't sound true, but for those of us who have been behind the scenes of the Wizard's Light Show, we are here to try to explain to you that when you go in these courts, it is a dog and pony show, especially if you're involved in a criminal case. It is a dog and pony show. They are selling prisoners on the stock market. They are making mortgage-backed securities out of prisoners, and they're making mortgage-backed securities out of everything in the country. Everything in the country is for sale. Everything is for sale. It's been securitized. Every time you buy a car, they securitize that contract. Matter of fact, let me share something with y'all real quick about when you buy an automobile. I don't know if y'all know this or not. But when you buy an automobile, The Federal Trade Commission and the Financial Accounting Standards Board, which are responsible for GAAP, which is generally accepted accounting principles, which all federally insured institutions have to follow, made them put a notice on the application whenever you buy a car. And most of y'all probably don't even read it. You're buying a car, you're filling out the paperwork, and there's a little, and they make them put it in big font. They make them put it in big font, and there's a box there for you to check. And what that box essentially says is that anyone who purchases this contract purchases subject to all the claims and defenses that the borrower could assert against the original lender. And a lot of you out there are not understanding what that is saying or what that is for, because it's not for you. It's not for you, but now you're supposed to check that box. Because what happened in 2004, a lot of y'all don't know this. I'm gonna drop this on you because they kept it. I don't know how this didn't make the news. But in response to the Enron scandal that everybody was talking about, everybody knows about Enron, which was what was behind Enron was a lot of accounting trickery, because that's all what this basically boils down to is sleight of hand trickery with accounting. Well, what happened then is that the Financial Accounting Standards Board wanted people to get full disclosure about their right of set off. This word set off. Now, a lot of y'all out there might think that that's a good thing. They want to tell us that we got a right to set off our debts. But no, they just wanted you to put it in the contract so you can waive that right. Because the only way that you can waive a right is if you know about it. So they want you to waive it. So on these automobile contracts, you're going to see something. You're going to look for it. It's on a loan liner agreement a lot of times. It'll say, Consumer Claims and Defenses Notice. I'm reading from one right now. It says, notice, any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods and services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. And you notice it's going to have you a box for you to check. And it says the following paragraph applies to the advance only if the box is checked. You got to check that box or you waive that right. These people are slick. The only way I found this out is that I was researching securitization, and I went to Google and I put in securitization, isolation, and all these letters from attorneys and the chairman of the American Securitization Forum, which probably y'all don't even know about that particular organization. The chairman of that forum, he is the one who started all this securitization stuff, one of the founders of it, is giving letters of explanation about set-off. These letters are some of the most educational material that you'll ever read because they're going back and forth with the Financial Accounting Standards Board giving explanations about your right to set-off. And what is a set-off? Set-off is your right to get rid of your mortgage, your right to get rid of your car note, your right to get rid of your credit card bills, all that shit. And what's real interesting, that in these documents, they allude to the fact that the general public is too stupid to recognize these rights. That's what's real interesting about it. And this is what's in all these car contracts that you get. And the Federal Trade Commission made them put that there. You would be wise to start looking at all these letters, these people, what was happening in 2004. Google the word securitization and put a comma and then put the word isolation. When you're isolating a particular instrument, What they do is, see, all you people out there doing these foreclosures, y'all keep talking about the promissory note is not in the trust. The promissory note is not. Where is the promissory note? The promissory note is a security. It has a maturity date over 9 months. It's no longer a negotiable instrument. They do not transfer the promissory note into the trust. They transfer all rights, title, and interest that they can into the trust. It's called a true sale. But to be constituted a true sale, they have to have enough of those rights. And they can't get all those rights because you, as the alleged borrower, retain some of those rights. And one of the rights you have is the right to set off. And that is why set off is a counterclaim. And anytime you come into these foreclosure proceedings, your counterclaim should be set off. This is not me saying this. Go read their stuff and see what they're saying. They're just speaking in a language that they think that you will not be able to understand. They don't think you know what derecognition of an asset off of a balance sheet means, or what an FR 2046 balance sheet report is. Anyway, that's my morning rant. Let's get to the documents I wanted to talk about. Ten top documents. Oh, sir. 10 top documents that you can go on the internet that will educate you so you will find out what is going on. And you can see if you go to my stream, you will see where I have listed all of those, that whole list of documents for everybody to start reading. The first one, number one on the list, is creditors and their bonds. It's going to be the hardest document for y'all to find on the internet. I have found it in one place in the last 5 years, and that's on Adam Addis' website. He has it named, It Only Hurts When I Laugh. That's how they call it. That's what they named the document. It Only Hurts When I Laugh. But that's a very, very powerful document. One of the best documents I've ever read to this day. Teaches you what is going on behind the scenes and also how to do an administrative process. And when I say administrative process, what I mean is this. An administrative process means before you ever go into a courtroom, you need to have already have done something administratively to resolve the conflict. That's what the Fair Debt Collection Practices Act, the Truth in Lending Act, and all these acts have been put in place for you. So you could have, those are just little things that they give you so you can do some type of administrative process before you get into the courtroom. But those are like bullshit type administrative things to do because they never address the substance of the fact that there is no money. There's no money. There's no money. I just got a call. Somebody told me they're on a call, and they're doing like a conference call on the internet. I hope they're listening to this. So I'm gonna go ahead and say this on the air. They're having an issue in a federal case, and they're having a conference call with the attorney and the judge, and the individual is on the line. And they asked the judge, is this an Article 3 court? And the judge said it's an Article 3 court. Now, the judge has said this on the telephone. What you want to do is you want to get that judge to see that's just a presumption. Get that judge to swear that this is an Article 3 court. Get that judge to go on the record and say this is an Article 3 court. Now, sometimes they'll try to trick you and say, well, I'm an Article 3 judge. Yeah, you are an Article 3 judge, but is this an Article 3 court? Because if this is an Article 3 court, then the question that you should ask that particular individual is, where is the injured party? because it cannot be the United States versus you, or the state of so-and-so versus you. Because if that is the case, then okay, well, let me face my accuser, because the Constitution of the United States gives me the right to face my accuser. So say, okay, well, if it's the United States versus me, then call the United States to the witness stand. Where's the injured party? For a judge to say that this is an Article III court would be the biggest screw-up of his career. He'll never say that on the record. So for the people sending me the messages out there, I hope that answers your question. These are not Article III courts.
That's a good point. Thanks for letting me back in because my computer's froze. Yeah, that's a real good point. That he's going to tell him on the telephone that it's an Article III court, but he sure as hell ain't going to say it's an Article III court.
Man, ain't going to say that and on the record in court. Man, they lose their job.
Or in public, in front of anybody who can testify.
Anybody else, man, they be lying. It's just straight up lies, you know. It's like, okay, because, you know, in court, they don't have what's called a lie. They have what's called perjury.
That's right.
And the reason it's called perjury is because you have to be under oath. So if I say anything in a courtroom and I'm not under oath, it's not a lie. It's called a presumption or an assumption. It's not a lie. You know, they come into court, people say, well, the attorney said, the prosecutor said, I had 15 AK-47s, some dead bodies. And I didn't have any of this. What is he talking about? And you get all excited. He's lying on me, man. The prosecutor's lying. Is he under oath? If he's not under oath, it's not a lie. It's a presumption. He's presuming something. It's called hearsay. That's why there's a word called a rebuttable presumption that you can look up in the law book. And you simply say, objection, Your Honor, hearsay. If counsel wishes to testify, please have him take the stand and go and swear under oath so he can subject himself to cross-examination. You ever see that movie True Grit, the new movie True Grit?
Yeah.
The new one.
Yeah.
That was a tight movie, you know, because in there, you know, when the dude that she hired, you know, the bounty hunter or whatever, you know, he was on the witness stand. He was getting cross-examined, you know, and that defense counsel said, objection, Your Honor. Counsel wishes to testify, have him swear in. Because that's just a staple in law, you know what I'm saying? These attorneys will be talking all the time, and everything they saying out of their mouth is hearsay. That's why they have to call witnesses and have them swear in and then question them on the witness stand, because the attorney doesn't have firsthand knowledge of nothing. Neither does the judge. Every time the judge says something, it's a presumption. We don't have to do that today. Oh, yeah? Are you the law? Are you the law, or is these codes, rules, and regulations that you have to follow the law, and is the Constitution of the United States that you swore to uphold, is that the law? Is that what's regulating you? Because they'll get on the stand and say something sometimes, even tell you to be quiet sometimes. Which you should fire back. Am I to understand you made a determination I'm not to be given my due process rights of freedom of speech, because the Constitution of the United States gives me freedom of speech. I can say whatever I want to say. That's a restraint on a government public servant to tell me to shut up. That goes for you police officers out there, too. You'll tell me to shut up, man. As long as I'm not disturbing the public or anything like that, I can say whatever I want to say. Or infringing on somebody else's life, liberty, and pursuit of happiness. Let's get to the business, though. So we had the first one, and I hope y'all, that little jewel I dropped on y'all about when you buy the car, y'all need to pay attention to it. Always check that box. Because what that lets them know, it lets some investors know on Wall Street that your ass, if you buy this contract, if I set it off, your ass is out of gas. You be in the bank filling out the application. They just gloss over that. They'll just say, sign here, sign there, sign here, sign there. Whoa. Let me go in the car, get my pocket Black's Law Dictionary. Let me come back in here. I'm going to sit down in the lobby. I'm going to read this thing. I'll get back with you in about an hour. Read this thing, see what y'all trying to say. And the protocols of the learned elders design, they talking about the Goyim. They said the Goyim, the Gentiles, the lawless ones, don't read paperwork that they sign. Put their signature on anything. And sign their signature unqualified. Every time you sign your signature, there should be something behind it. UCC 1308, or better yet, the state code for 1308 that's in your state. Without recourse, coactus specie. Coactus specie, by the way, means that you have forced me to do. So if somebody going to force you to do something, whether it's a traffic ticket, whether it's to sign a bond to get out of jail, go on probation, or whatever, sign coactus specie. Y'all forcing me to do it. I didn't agree to come in this motherfucker. Let's get back to the business. Top 10 documents is what we're talking about today. Second document, law redemption in court. Now this one is a real nice one because it gives these people the business, and it really, what I like about it in part 4, it tells you what to say in court, what to expect. What is happening when they ask you for the name? How it's a contract that you're being involved in? How to make the judge liable? You got to understand, when you look at these transcripts and everything, you'll see it just says the court said this and the court said that, and they ask you for your name, and would you state your name for the record, and would you please spell that? Ask them for their name. And tell them to spell it. And watch out for the trick. The trick is, my name is Judge so-and-so. No, that's not your name. That's your title. Your name is Bill Smith, not Judge Bill Smith. This is how you get them to be liable in their personal capacity, because they're going to use their public capacity for immunities purposes. Because in the public, they are, as long as they're following the ambit of delegated authority, they're immune. But you're acting in your private capacity, and this individual has sworn to uphold the Constitution of the United States that's going to protect you in your private capacity. So this particular document, Law Redemption in Court, is a very, very, very good document. I strongly advise everybody to check it out. The next document, if y'all see on my stream, is the Gene Keating Workshop, and he also has a Prisoners Treaties. They're two separate documents. The Gene Keating Workshop, I'm going to give Gene Keating his props. Gene Keating is one of the first individuals to come out, at least that I know of, that was talking about the GSA bonds and how to use those to get people out of jail. You should also read his prison treaties that he puts out. The man dropped everything that was going on behind the scenes with the prison industrial complex. If you are in this game, that is required reading, especially if you have someone who's locked up in jail. Especially if you're just out there and you just listening while you're working right now, probably going, what the hell is he talking about? What does he mean that the criminal justice? Because you got a lot of people out there, y'all in Wonderland or something like that. Y'all don't know what the hell is going on. Y'all think somebody get arrested. I don't know what he did, but he shouldn't have done whatever he did. And then you got, some of you black people out there. You need to leave them folks alone, boy. Told you don't go messing with them folks. This show is not for you. Law of Redemption and the Gene Keating Workshop definitely required reading. Definitely. Now I'm gonna give you this next one, which is a very good one too. It is, what is acceptance for value? Excellent document. You can Google this on the internet. This explains the public and private and how they extend credit from the private into the public. Notice they use the word extend credit. It also explains what's happening when you get an indictment, how they are a transferor and you are a transferee, and how there's a trust relationship that establishes and you become a trustee, and then you have a duty to perform. And if you don't perform that duty, there's some liability that's associated with that. The trustee always has the liability. This is a very, very good read, and you have to study this book because it's not an easy read. But it's a required reading. It's going to give you a foundational understanding of public and private and how the Uniform Commercial Code applies. Because a lot of y'all are out there using this word accept. I was on a show yesterday on Don's after party. They're talking about acceptance for value. They don't understand because they didn't read the Uniform Commercial Code. There is no word acceptance for value, but there's a word acceptance and there's a word value. And these are explained in the Uniform Commercial Code. Get an in-depth understanding of what you are saying and what you are doing. Now, this next one, number 5, because we're going to talk about these traffic tickets real quick. These two next documents I'm going to talk about are the best documents you can get on the internet, hands down, that talks about your right to travel and talks about how to get rid of traffic tickets. If y'all want to start a business out there helping people get rid of traffic tickets, these are the documents that you need to get. Now, the first one is called, which is I love, it's one of my favorites, called Court Survival Guide. You can Google that, Court Survival Guide. Now, a lot of you astute people out there, what I'm going to call geniuses, will be able to read this document, and you're going to understand that this not only applies to traffic tickets, it also applies to a criminal case or anything you're dealing with in the judicial system. This document is one of the best reads that's going to explain all your rights, all the tricks, just like what we were just talking about Article 1 and Article 3 court. Like a judge just got through saying a few minutes ago, this is an Article 3 court. Oh, it's an Article 3 court. It is. Well, where's the injured party? That's automatic dismissal because there's no injured party. And an injured party has to sign an affidavit stating that they've been injured. So please present me an affidavit from an injured party demonstrating that there's an injury that I have occurred that I'm liable for. Or if it's an Article 1 court, which is about contract, then please present the contract and put it in evidence and show me how I'm obligated to, how I'm bound to this contract, because I'm not aware that I signed any contract, whether implied or in fact. This court survival guide is a badass document. It is definitely something that you need to have in your library, and it's something that you should be studying. I used a lot of stuff out of this document to defend myself in federal court. Always have something new in your arsenal when you go into these courtrooms. Because they got a study, man. I just told y'all yesterday, they got the anti-government handbook where they telling all these judges how to handle us when we come in these courtrooms, which I can't understand how it's anti-government when I'm coming in trying to serve my rights. I'm asking you questions about the Constitution, and I'm deemed as anti-government. That should be telling you something. They're not following the Constitution. But you won't know that unless you ask the right question. Y'all go in there and don't even ask no questions. The person asking the questions is the one always in control. The person asking the questions is always the one in control. The person answering the questions, you are the slave. You have to develop the skill of answering a question with a question. Because everything they do is all presumptions and assumptions and color of law. So every time something comes out of their mouth, you should be looking for clarification in the form of a question. How do you plead guilty? Well, before I plead guilty, sir, I'd like to know the nature and cause of this action. Would you help me understand that, please? Are you ready to go to trial today? Well, I conditionally accept the honorable judge's contention that we're going to go to trial upon proof of claim. You can show me some points of law that shows me that we need to go to trial after I've accepted all these charges for value and consideration, and I'm not disputing any of the facts. Get your game up. Your verbal game. It has to be on point. We got a lot of people on the call today. Woo. Y'all must be getting the word out there. All right, let's keep it going. Let's keep it going. The next one is also a traffic ticket document. It's called Abatement in Common Law. And it's by Don Quixote. He's a JD. Shows you how to do an administrative process on a traffic ticket. Now, for all you naysayers out here, let me repeat. This is a JD, a Juris Doctorate. This ain't some patriot guy. And he also tells you how these are not Article III courts. Very, very good document. At the end of that document, if you have a federal case, it shows you how to abate a federal case, a federal indictment. What y'all don't know out there is that when they indict you federally, they just show up at your house with an indictment with about 50 armed agents coming to get you because you jaywalked across the street. And then why you coming to all these people with guns, man? You can abate that because you have a right to voir dire the grand jury. That's under Rule 6B of Federal Rules of Civil Procedure or Criminal Procedure. That means to tell the truth. That means you got a right to question who are these people, these grand jurors that you allegedly went to get a true bill of indictment to come and arrest me and restrain my freedom. You never even get to meet them. That document explains that better than anything. It will make you a PhD in that if you take that and read it. And I mean read it. Let's keep going. The next one, number 7, is the matrix in the Constitution. And I'm going to put 7 and 8 together. It's the matrix in the Constitution, and the other one, you got the Great American Adventures, Secrets of America by Judge Dale. Judge Dale wrote both of these documents. And in this document, they're going to give you the best explanation in here of how to appoint the judge as the trustee in the case, and give you an explanation of why. Because as I already told you, every time you see that all capital letters name in the caption of your pleading in any court case that you're in, that is not you. That is called a constructive trust in equity. A trust can only be enforced in equity. And a constructive trust is a legal fiction. If you look up the word legal fiction in your Black's Law Dictionary, you will see at the end of the definition, it will say, see constructive trust. It's a fiction of law. So, with a trust situation, you have 3 parties, a trustee, a trustor, and a beneficiary. You are the beneficiary. All the time you identify yourself as the beneficiary. These people are our trustees. They are public servants. When you go into the Social Security office, they tell you your Social Security benefits, don't they? Why the hell the government at one time they're a trustee over your money when it's time for you to get your money, and you come in the Social Security office, you get a benefits, and you're a welfare recipient, and they give you $200 a week, but now you want to bring me into court, now I'm a trustee. Because the trustee is always liable. You're the beneficiary, and they have a fiduciary duty to protect your rights. All right, let's get to the next document. You can Google all these on the internet. As I made these, we can Google them on the internet. The next one is the exemption and using your exemption. Those are two separate documents by a man named Moses Washington. But one of them is called the exemption, and the other one is called using your exemption. Very good document, has a very good example of an international bill of exchange or a bill of exchange in that document that is very well put together in using your exemption, as well as a promissory note. And it explains the exemption probably better than anything out there that you're going to read. The number 10 document is paper arrows. And I'm going to tell you why I like paper arrows. Paper arrows is one of those documents because the gentleman who had been studying law and doing this for about 20 years. And it's Howard Griswold is the author's name. And in this book, he demonstrates how the Constitution, one of the first things he makes apparent, makes everybody realize is the Constitution don't apply to you. It's a limitation on governmental powers. Very, very good document. But it also lets you know how there's fraud everywhere in our society today. This is why when you write the bank, you can't get a straight answer. This is why you go into court, you can't get a straight answer. This is why you go down and try to talk to the clerk, you can't get a straight answer. This is why when you call the Secretary of State, you can't get a straight answer. This is why when you go up to the dealership and ask them a question, you can't get nobody on the public side is going to give you a straight answer. Because everybody knows that everything is fraud. And this is a very good book that seems to go into this. Now, also I got some honorable mentions that I want to run through real quick. And the first one is the Affidavit of Walker Todd. Definitely a document you need to Google on the internet. Walker Todd was an attorney who was an expert witness in a case, who gave this affidavit basically telling all y'all out there in America that there is no money and the banks didn't loan you shit. All the naysayers out there. This is a document you have to study. Because this is from an attorney. You know, a lot of people, they feel like it ain't coming from an attorney. It's a lot. I know it's a lot of y'all out there feel like it's not coming from an attorney. Y'all still under the spell. You're under the spell. You have to have it. Even though the attorney keeps screwing you over again and again and again, taking your money and everything, you're going to stay under the spell. Won't try to find out nothing for yourself. This is a very good document for you to read. Affidavit of Walker Todd. I put this affidavit into a court case, in a foreclosure case one time. The judge called all the clerks up from the office and said, "Can we please take this out of the record?" And the clerk said, "No, we can't." And I told him, "Well, we can use that like a citation of authority, Judge." Use it as an exhibit, attach it to my complaint. He said, you're right. They didn't walk that in the record. I use that as one of my exhibits, along with that memorandum of law for international bills of exchange. Because when you come in there and when you tender these people these negotiable instruments for discharge of your debt, you got to give them the law to show them that I can do this, and you put it in the judge's face, and you reminded of, hey, judge, did you get my memorandum of law? Because don't sit up there on that bench acting like you don't know what the hell I'm talking about. Very good document for you to read. Affidavit of Walker Todd. Let's go to the next one. Now, this is a very obscure document. That is a very, very good document. The guy's name is Hfrn, and he put a document out called How I Fought My Property Tax Foreclosure Case. Now, in this document, I spelled tax wrong also on my thing, y'all. Forgive me. But in that particular document, this dude did an administrative process to save his house. And he outlines and shows you how he did it. He even shows you the money order that he submitted. Now, the thing that he did that was very, very powerful is he went and found the Yusef number. Y'all need to look at this man's documents and see how, but the key to everything he did was he found the Yusef number on his particular loan. Study that document very, very closely. That's a powerful document. That's some powerful information. It don't apply just to property taxes. It applies to any type of case that you're involved in, because I've used it on other cases. How I Fought My Property Tax Foreclosure Case by Hfrn. Google it on the internet. Another document that everybody should be on the internet Googling and finding out about is Cracking the Code, 3rd edition. I don't particularly like the new one, Redemption in Law, but I like the Cracking the Code, 3rd edition. The Cracking the Code, 3rd edition, it shows you how to, put together. Cracking the Code is like the book that kicked all this off for a lot of us, Them boys, I got to give them their props. They started a lot of this stuff, putting information together, putting it all in the prison systems and everything, exposing it, got people whispering about this book. This book is a legendary book. You should have it in your library. But in particular, I want to point your attention to Chapter 10 of this book. Because Chapter 10 in this book shows you how to copyright your name. You need to copyright your name. Copyrighting your name is very, very important. They make it seem like it's not important, but it is important to copyright your name. Because I've had instances where sheriffs have actually asked me, looking nervous as hell, was my name copyrighted? But they're only going to be nervous about you if they see you the type of individual that don't bullshit. They ain't worried about no scary, meek, timid, wavering, person who waver back and forth, motherfucker. They not scared of you. They are afraid of the individual to say, this dude right here, he's intelligent. I don't know what he could possibly do. He might lean me up and take everything that I own. There's a video on the internet. You should get on YouTube, and you should check it out. It's a video of this guy. It's called "Cussing Out the Judge," and the guy is like dressed in an orange jumpsuit. Just go on YouTube and put in "Cussing Out the Judge." And this dude, he's coming in, he's just cussing out the judge. He's just straight ghetto with it. Just, you ain't nothing. You just a woman like anybody else, and I wish you died when you was born. And, he talking like that, to the judge, the prosecutor, everybody. And what was interesting is everybody would just stand around, let him talk and everything. The judge didn't know how to handle it. Now, the thing is he had the right mentality, just the wrong delivery. That is the attitude that you want to have. You need to go and watch that video, and that is the attitude that you want to have. But when you speak, it needs to be intelligent, and it needs to be stinging with intelligent words, with insight into what you're doing. But the attitude that you want to have is just like that gentleman had. That is definitely the attitude you want to have. Now, let me go to number 15 real quick, which is a very, very important document. But this is only for upper-level students. This is not for beginners right here. This document is not for the beginner. It's called The Clerk's Praxis by John Hall. Took me 6 weeks to go through this document in a place where I had plenty of time to look through it. So I know most of you out there who are busy with everyday life may not have time because it's an old document and it uses a lot of old terminology. But see, the reason you have to read documents like this is because it has all the principles contained in it. They're not covering things up. This is how I found out that admiralty was just not about the law of the sea. See, you got a lot of ignorant people out there talking about admiralty is just the law of the sea. Admiralty does not have anything to do just with the sea. Admiralty is about the subject matter. And that subject matter is commerce. Then, after you read this particular document, study it, look up every single word in it because it's has a heavy amount of legalese in it. And they use a lot of old words. They don't use words like bond. They use words like fiduciary, caution. Those are the equivalent of today's words we use for bond and surety. But when you study these old documents and then you bring it forth to today, you can see how they're doing the same thing, only they're just using different names. This will develop your insight into what is going on. Hello? Didn't you listen to my show? I answered that question on. I got a phone call came in. I got some calls coming in, some questions. 302-384-749. You're on High Frequency Radio. How can I help you?
Them documents. Matt, Walker Tide. How are you spelling Tide?
Tide is spelled T-O-D-D.
Oh, T-O-D-D?
Uh-huh.
And you Google that online?
Every document I gave you, you can Google on the internet.
Well, Mac, let me see. You said Mac somebody.
Particular individual, that individual is, his name is, I put that on the stream. I put all their names on the stream when you go on there. But his name is, if you go to my website on the stream, I got the list of all those documents. But his name is Mac Harry Fisherman. And if you go to the site for this particular show, I don't know if you got access to the internet, But you can go to blogtalk.com/high frequency, and I got everything listed right there.
Blog.
Blogtalkradio.com.
Radio.com.
/high frequency.
You said /?
Yeah, /high frequency.
All right.
And you can, and you will see when you click on that, and you'll see I put everything right there for you. So I put a list of all the documents that I'm talking about. As a matter of fact, that's what I'm reading from right now. I'm reading right off of that.
All right. Thank you.
You're welcome, sir. Six 778-760-3490. Welcome to High Frequency Radio. How can I help you?
I have a question.
Mm-hmm.
If you are on a conference with a judge and he states, you ask the judge under what article is this court operating, and they state an Article 3 court.
Okay. Obviously, because I already know where you're going with this. So I'm going to tell the audience, this is who's been calling me on my private line, because everybody out there in radio land has heard me answer this question, so I'm going to answer it for you again.
Please
all right?
do.
What it is this. When you're on the phone with a judge, all right, or an attorney, and they make a statement like that, they're not making it under oath. That's a lie. I'm going to just straight up call it what it is. It's a lie. What you say, you ask them, would you be prepared to give me an affidavit or be in court and go on the record and say that? Because I guarantee you that judge won't go on the record and say that. That right there should let you know that you're in a kangaroo proceeding and none of these proceedings are being recorded.
But if it were being recorded, because it was.
But it's probably not going to have any basis or any impact on the proceeding. But if he said it's an Article 3 court, then if he says Article 3 court, then just tell him this. Okay, well, who's the injured party? Because for an Article 3 court, you have to have an injured party who has an affidavit sworn out under oath, under penalty of perjury, that you've injured them. So who's the injured party?
That's my point exactly.
And if he says the United States, then he said, well, okay, I'm going to call the United States to the witness stand, or the state or whoever.
Okay.
You know what I'm saying?
Really
you can't call.
I was shocked that he responded Article 3.
Because he knows he can say that in that event. Get him in a courtroom and see if he'll say it. What are you going to do in a courtroom? He's going to say, we're not here to talk about that today. He's going to start doing all type of stuff to try to evade that question.
Well, what he did is when we tried to go into the nature and cause of this action being commercial, he immediately cut it off.
Of course, because 27 CFR 72.11 says it's commercial. What's wrong with these people?
We stated that on the record.
Well,
and then he insisted that we needed to have the evaluation done.
Well, that's going to happen. We talk about the evaluations, but you don't have to follow any orders of a judge. You haven't been found guilty of anything. Why I got to follow your orders? You haven't even proven you got jurisdiction over me.
Well, he said that if...
listen, I don't care what he said. You don't have to do anything that he says. Now, this is going to be predicated off of you bold enough to do that. I've been through that. I've been through the mental evaluations and everything. I do nothing the judge said to, because everything is voluntary. Because to put you under a mental evaluation would mean that you are testifying against yourself. And if anybody read the Fifth Amendment of the Constitution, it tells you that you cannot be compelled to be a witness against yourself.
Well, we stated that on the record, on the call.
Okay, that's fine. And he's going to say whatever he wants to say on the record, and that's fine. He can say whatever he wants to say. But the thing about it is up to you to challenge it. If you don't these are contract courts. He's making a contract with you. So if he says something like, well, I'm going to order you to take a mental evaluation. Okay, well, I conditionally accept you can put in an order for that upon proof of claim. You can show me that you can do that without violating the Constitution, my Fifth Amendment rights. And see if he answers the question. He's not going to answer the question. These people, listen, y'all, because I'm glad you called in with this. Because a lot of people out there don't understand what's going on behind the scenes. They don't understand how dirty the federal government is. And one of their biggest things that they like to use when people start questioning jurisdiction is competency exams. What it is they're trying to determine if you know how to handle your commercial affairs. You have to tender, now I know y'all's situation, you have to tender payment for these particular cases. All right? You really don't want to question jurisdiction until they dishonor your process. When they start dishonoring your process, that's when you start wanting to question what they're doing. But the thing is you've already given this guy instructions, but you haven't even tendered payment for the particular case. These are debt collections. So if it's a debt collection, the first thing you want to do is provide him with anything, and then you're sitting here saying it's commercial, and you haven't given him anything.
Okay,
hold them liable.
That's on its way there, and we had to fire the attorney, obviously.
Well, yeah, they're going to try to do that, but the thing about it is you don't have to take anything. You don't have to take everything to do within their system is voluntary. That's what that federal judge said, that everybody who is locked up is there voluntarily. That federal judge said, he said, everybody who's in jail is there voluntarily. And people have to understand voluntary consent can be made to voluntarily do something through fear. Fear is a decision, is a choice to allow your fear to control you. And that's the hardest thing that I have in teaching this stuff is people are afraid. They let their fear overcome them, even though in their scriptures it tells them over and over and over again, don't be afraid. But people are professing to be something with their mouth, but their hearts are far removed. It takes a lot to see through the illusion, but you have to stand your ground. That is what's called standing on your square. That is what the belligerent claimant is talking about, even if you need to test it in contempt proceedings. I'm not doing anything. You don't have the authority over me like that. These people are trying to prove that you're slaves. It's not the first time. You can get on the internet. You can Google. You've already read that. You see they do that to everybody. They did it to me. I'm not telling you something I don't know. I'm telling you something I've experienced for myself. You have to do nothing. And what they're going to do is they're going to come in court and we get the results of the mental evaluation where you refuse to take it. What are they going to do? You don't have to take that. You got a Fifth Amendment. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Remember that. You want settlement and closure. When you get on that phone, you start engaging these people in too much conversation. I already told you, the thing you go in, and when you go in these courts, y'all, what you want is settlement and closure. You start giving directions. I'm appointing you the trustee. But see, y'all ain't got the balls to do that. So I don't know what to tell you if you ain't got balls. If you don't have the balls to tell this judge what you want him to do, then you're going to lose time and time again. All men are created equal. This man is not your authority, is what I keep trying to tell y'all out there. He's an administrator. I don't care what he says. He's going to say anything out of his mouth. Tell him to show you where it says that on paper. Where in the law does it say this is an Article 3 court? Can you demonstrate to me on the record through a point of law this is an Article 3 court? And you in here enforcing statutes? It takes balls. This is not for everybody. This is why I'm on here doing these calls, because the fewer people out there, it's going to be some people out there, they're going to get locked up, and they're going to be dragged around the country. And they're going to remember these things I said because the person who taught me told me this, and I ended up going through it before I went through it. So I knew what to look for. It's a big stage play. They are fooling everybody in the United States. And our biggest fault is we put trust in these people. We think that they are representing truth, justice in the American way, and they're anything but. They're not trusted. They're not public trustees. They have violated the public trust. They're in it for public profit. And they are desperately trying to conceal this fact from the public. And that goes for you foreclosure people out there too. Y'all putting trust in these people, and they stealing your property. Go inside of a bank if you got a car loan or something like that. Next time you get in a loan, sit there and ask these people, where are you getting this money that you're about to loan me for this house or this car? Where is it coming from? And watch the games begin. It's coming from reserve. No, that's against the law for you to loan out your reserves. We get it from depositors' accounts. No. Are you sitting here trying to tell me that somebody made a deposit in your bank and you took that money and gave it to me and I might not pay it back? Notwithstanding the fact that that is against the law? Well, now just sign this right here and get out of my office. Game. They do the same thing on all levels. Stay on the phone real quick. I got another call coming in. 6924. You're on High Frequency Radio. How can I help you?
Peace, Yusef. What's the deal? This Humble One. What's good, man?
What's happening, man? What's going on?
Chilling, man. I wish I had known about that car shit you was talking about like 2 weeks ago.
Did you see the loan liner I'm talking about?
Huh?
Get your paperwork and look at it. Did you see it?
No. Well, my girl liked to just sign shit without reading it, and while she was signing the papers, the guy handed us a wrong. Cause we was trying to finance. We're trying to not finance, but what's the other word? Not finance, the other one, leasing.
Right.
No, financing. My bad. We were financing the car, and he handed us a paper, and I'm reading the paper, and the shit said lease on it. And she getting ready to sign it. I said, oh, you're giving us the wrong paperwork. He said, oh, I'm sorry. So, yeah, where can I go look it up? Because I have the paperwork, and I want to look this shit up so I could know. And when we check that box, wherever the term is on that contract, what does that exactly mean? And if we do check the box, and, you know, how does that benefit us or not benefit us if it does?
Well, how it benefits you is you don't waive your right to set off, because what it is you're giving notice. It's a notice. You know, you're giving notice to the investors. Because what they do is they securitize your contract. Your contract, when you sign a contract for a car, that is like a promissory note.
Right.
All right. That is the instrument that they're going to use and monetize. But on that contract, they put that notice on there for the investor who's going to buy it, and let them know that, hey, if you buy this particular individual is putting you on notice that he is recognizing his right to set off and he's not waiving it. See, what it says is claims and defenses. You have claims and defenses. What are your claims and defenses? And don't let them tell you what they are. Find out for yourself what they are. This is why I tell people to study generally accepted accounting principles and the matching principle. Every time that you make a deposit of a promissory note or any type of negotiable instrument for that matter, they have to ledger that on their books as an asset and a liability. And what they do is the asset is the fact you just gave them some money. The liability is they got to give it back to you. But what they do in the cases of loans is that they do what's called off-balance sheet accounting, and they move that over onto another set of books. This is called off-balance sheet accounting. But they have to report that, and they would have to report that with an FR 2046 balance sheet report. That is why you want to subpoena that when you go to court. You're like, I want that information. I want your accounting records. See, the secret to find out what they're doing is to get their records on the accounting of it. But they ain't going to never want to give you that. But there is something you can do in court called a subpoena ducis tecum, which is a subpoena for documents. And what you do is you go down to the clerk and you ask them for some subpoenas, especially if you are representing yourself. And you put this on your schedule of what you want them to provide you.
All right, man.
So that's what that's for. like I said, get on the internet and Google isolation and set off. Matter of fact, hold on for a second. I'll see if I can put the link up real quick. Dude's name is his name is Vernon. There's a website y'all can go to. It's called the American Securitization Forum. My people probably don't even know about. There's some letters. I got letters dating back from the 80s where they were talking about where they knew that securitization was going to be questioned. In the 80s. This is how far back these people knew about this stuff. And what I did, I went to Google, and I Googled securitization and isolation. And isolation is a term that you should try to understand, too. Asset securitization, isolation, and then put in, you might even want to put a comma, American securitization forum. And that particular, I think his name is Vernon. Let me see what his name is. See if I can find it real quick, and I'll tell y'all what it is. Yeah, it's an FAS 140 set off isolation letter 5-1. Let me make sure this is it. Yeah, it's FAS 140 set off isolation letter 51004. You can Google that. And you can read this document with this individual. It's very educational. These guys are like dropping they giving you the knowledge. These letters that they got, they better than anything else you're going to read. They tell you stuff that you probably. This is how I found out about this caveat that's they put in all these car loans, and I went and looked at mine. It's right there, big as day. And I didn't even look at it. I'm like, wow, it's right here in your face. And even the Federal Trade Commission even tells them that they got to put it in big font. And it's right there, big as day, but people don't read it. I'm going to put a link up in the chat room for it. Y'all can go in the chat room, y'all see it. I'm going to drop it in there real quick. Oh, somebody looked like they already beat me to the punch. Crew royalty. That's a very good document that that y'all should study. So you can start studying and learning about set-off. You also should start learning about set-off on for setting off a balance sheet. There's a thing called setting off a balance sheet that you can do that as well. You should always check that out as well because they say you can only set off a balance sheet under certain situations. And you got to find out what those particular situations are for. I got a whole bunch of people in call to answer your question. I guess so. Five 5556. You're on blog. You're on High Frequency Radio. How can I help you?
Yes. That's new, sir. My name is Salim Bey. I'm trying to find those documents you was speaking about on your blog talk, but there's so many blog talks to punch into. Which one do I punch into?
Okay, you're trying to find my it's the latest one. You can go to blogtalkradio.com /highfrequency.rss. RSS. And when you go to that site, it'll pull up all of the shows, and it will show you the latest show. The latest show is entitled The Top 10 Documents. Top 10 Documents for you to research. It should. When you just go to High Frequency Radio, when you go to blogtalkradio.com /high frequency, it should be on there. I mean, it should list all of my shows. Wow, this man, the board is lit up. Okay, y'all, I'm going to get to all y'all's calls today. Did I answer your question? Okay. Let me go to the next caller. Let's see what we got in here. 7419, you're on High Frequency Radio.
I'm good. I didn't. Go right. You answered all of my questions.
Okay, all right. Hit number 1 on your phone for me so your hand will go down.
All right.
Okay. Let me go down here. 0400, you're on High Frequency Radio.
Hi, this is Cassandra. Can you hear me?
Yeah, hey, how you doing?
Hey, this is Cassandra from Atlanta. How are you?
Hey, how you doing? What's going on, Cassandra?
Okay, I pulled up, it's American Securitization Forum.
Right. It's the American Securitization Forum, as the name implies, they deal with securitization. And
his name is Vernon Wright.
Vernon Wright. That's his name. Yeah, his name is Vernon Wright. Now, Vernon Wright, what you do, this is the type of stuff I do. When I saw this individual, I started researching this individual. You're going to see this is a very powerful individual.
Mm-hmm.
All right, you're going to see he's taking pictures with all type of people. Vernon H.C. Wright.
Mm-hmm.
I've never heard of him before. But when you go see the bibliography on him, you're going to see that he was a participant in the creation of all this securitization stuff. So you definitely want to read his information and start seeing. Now, of course, they write this stuff in a way that if you don't understand the terminology, you won't be able to read, because in some of this stuff you're going to read between the lines and understand what a set-off is. You're also going to have to understand gap. You're going to have to understand gap also. And the matching principle. And that's why I'm telling people to read the affidavit of Walker Todd. The affidavit of Walker Todd will also explain that accounting a little bit more. And you read what's called the Financial Accounting Standards Board puts out all these statements. The thing that everybody was arguing over was FAS 140, and you could Google that. And that talks about setting off debt. And balance sheets and things of that nature. So, this is accounting things that they don't want us to know about. It basically came down to the fact that they didn't want another Enron scandal to occur, and they wanted us to waive our rights because they wanted to have these assets to be secured for their investors, and they really didn't feel like they were secure because you, as the borrower, always have these rights of set-off. So they try to figure out some kind of way to make you waive those rights. And they always want to give you full disclosure. So now they're putting these things in these documents, you're not really aware of what it's talking about.
Okay.
You see what I'm saying? And that's why I'm putting it out here like this. These are documents, they don't even feel like most people's going to even read this stuff. And you go and look at your car loan documents, it's right there. You're like, damn, I went and looked at mine, I'm like, damn, there it is, big as day. And then it tells you the following paragraph only applies to the advance only if the box is checked. And they put a little box there for you to check. But they'll never tell you when you've been there buying it. They don't go through the document with you. They just hand you a document, sign here. If you want to get your car, you want to get on the hell up on out there and drive.
Right. Sure,
you
you're
ain't paying no attention. And they do that a lot. And we got to stop doing that. We got to stop doing that.
Okay, well, I love your information. Keep up the good work, and I'm just going to keep listening.
Okay, thanks, Cassandra.
All right, bye.
Have a nice day. Bye-bye. 6924, you're on High Frequency Radio. Wait, hold on, let me get you in there. 6924, you're on High Frequency Radio.
My bad, Yusuf. This is me, Humble. I hung up the phone when you was talking, and I called back in, and you said, "Did you answer?" And I was like, I wanted to say yeah, but you couldn't hear me.
Oh, okay.
So, yeah.
All right. Okay.
I'll push 1.
All right. 6879, you're on High Frequency Radio. How can I help you? 6879, you're on High Frequency Radio. How can I help you?
Good afternoon, Joseph.
Good afternoon. Hello?
Yep.
Yeah, you going in and out. You going in and out. I tell you what, call back from another line because your phone is messed up. All right. (302-5556). You're on High Frequency Radio. How can I help you today?
How you doing? We got cut off somehow. I was asking you how to get to the blog. How to get to the website for the documents and stuff.
Oh, okay. Well, you should be able to just go to blogtalkradio.com/high frequency. And it's the first call. The name of the show is Top 10 Documents for you to read on the Internet.
Okay, Top 10.
Yeah, Top 10 Documents. I think that's what it called. Ain't what I called it, yeah, Top 10 Documents.
Because I'm there and I don't see anything. So I'm
okay. You want to? I tell you what. Let's see. Go to High Frequency. Go to Blog Talk. I tell you what. Go into the search engine and punch in the rules to the game.
Okay.
You should see all our shows too. The rules to the game. Yes.
Okay. I want to ask you a question. Do you do like seminars where somebody pay you to come in and you do a class on this stuff?
I'm already scheduled. Right now I'm trying to put together some seminars right now. I'm actually going to start probably on the East Coast and head across the country. So, yeah, I am in the process of doing that right now.
Okay.
Got somebody I'm speaking with right now doing that.
Okay.
I've done seminars before, too, in the past.
Okay. Now, I'm going to ask you a question. How about the nationalization process? Is there a way that you can lead me in to get that done?
Yes, and we'll talk about that when you say nationalization, but I want you to understand that sovereignty and commercial remedies really are not homogeneous. They don't have anything really to do with each other. And I'll have to explain that, further on in the call. But, hey, y'all, our stream is about to end. If you want to stay on this call, you're going to have to call in. We've got about 3 minutes left. We have another hour of the show, but all of you who are in the chat room, you're going to have to call in. The number is 424-222-5250. Once again, that number is 424-222-5250. Let me put that in the chat room for you. 424-222-5250. That's our call-in number. If you want to continue in on the call and listening on the call, we got another half of the show. And I'm going to have to take a break, brother, but I can bring you back in after we come from the break, okay?
Okay. I appreciate it. Thank you.
Okay, and I know all y'all got some questions out there. Just stay on the line. I'm going to get to everybody's questions. I see all of y'all in queue. I'm going to get to your questions, okay? And we'll be back after these messages.